Okay, just following on from Danny, just a heads up. We'll start at 5 past just to give those a chance to get into the room, and so exactly 5 past, you got a chance to get a cold drink, a milkshake, a cup of coffee, or whatever, and we'll join you at 5 past. So those who are coming in, thanks for joining, and we'll be with you soon. Okay, it's 1 minute past one. We'll start in another few minutes at 5 past just to give everyone a chance to join. So, those who've joined recently, I did make that announcement a little earlier. If you just get yourselves ready, and we'll be joining you in a few minutes. Thanks. Okay, it's almost 5 past. We're going to start in under a minute, just to welcome everyone. Just a point of to note that there are issues with the internet. It's at the Tom Jones syndrome. It's not unusual, and so we'll just, if there are any issues, we'll rectify them in one way or another. But for the time being, welcome. Thank you, Jackie, for preparing for this update today. And thank you, everyone, for joining us. And I'm not going to go into a whole introduction because Jackie needs no introduction. So look forward to a pleasant afternoon and a lot of information. And Jackie, it's 5 past. The floor is yours. Sorry, by the way, we will stop at 2:30 for a brief break in the seat if you want to go for a swim or whatever. But other than that, Jackie, thanks for joining and thanks for taking over at this moment. The floor is yours.
Super. Thank you. Thank you, Stan, and thank you, Danny. And good afternoon, everybody. It is lovely to connect with you this afternoon. Lovely summery day here in Joburg. I've had a meeting with some of my colleagues who are based in the Cape, and it doesn't look as if they're having the lovely sunny weather that we're having, but hey, we could enjoy the nice good weather in Joburg. So today we are talking about a case law and tax administration update. And actually, even if we just said a case law update, most of the cases we deal with these days involve tax administration. So yeah, it's all about tax administration when it comes to the legal matters, legal disputes. There are some issues that cut outside of that, but by and large, a lot of the cases that we are dealing with today are involving tax administration matters. So it's a good update on tax administration. And of course, tax administration, as much as it links into the Tax Administration Act of 2011, which became effective in 2012, right? So we've had it now for 13 years. And yet we are still learning more and more all the time about the actual application and interpretation of this Tax Administration Act. I remember being involved in some of the training, obviously, when the Tax Administration Act went live, and we were sort of putting forward what many of these provisions actually meant and what the interpretation was. And we've learned so much more since then. And I think all of us as accountants have had to delve into a lot of legal aspects and learn things about law that we either never knew, or maybe they were just deeply buried in our sort of Com Law 1 studies from many, many years ago. So yeah, tax administration is definitely an area that we need to grapple with, and it's really important, especially if you are involved in any aspect of the dispute resolution process for your clients. You know, all of the stuff we're dealing with today, well, the mere fact that it's case law means that there's been a dispute and it's gone through the courts. But it's also really important to understand what the evolution is in terms of the interpretation of many of these provisions. And of course, some of the provisions have changed over the years, so we need to keep up to speed with what those changes are. So as Stan mentioned, we'll run through until 2:30. We'll then take a 15-minute break until 2:45, and then we'll carry on through until 4 o'clock. We'll be done by 4. And if you do have any questions as I go along, you're very welcome to pop them into the chat. Um, I've got the chat box open on my other screen, so don't worry, I'm not watching the cricket or anything like that. I'm just having a look at my other screen from time to time to see whether there are any questions. And if any questions pop up, I'll try and deal with them as they arise. Okay, and then of course, if you have time to think, well, maybe if you go for a swim, then the freezing water will wake you up and make you think about all sorts of tax administration things. So if you come up with any questions during the break, obviously you're welcome to log those, and I will just check at the end of the break to see if there are any questions as well. And then there's a few minutes at the end of the webinar. As we wrap up, of course, there's a chance for you to ask questions as well. Okay, so let's go straight into it. The outline of what we are going to be covering today is, of course, as I mentioned, a lot of tax judgments, Constitutional Court, Supreme Court of Appeal, High Court. There are so many cases that we certainly don't have time to get into any of the tax court cases, although there have been some very interesting tax court cases that have been decided over the last year. But let's leave those, and if there are any important aspects there, I'll pick those up in the year-end update. Don't forget that we are doing a year-end tax update. I think that is towards the end of, well, I know it's towards the end of November, just not thinking of the exact date right now. But if I'll tell you, it's on the Thursday, the 27th of November. We've got our year-end tax update, again from 1 until 4. So keep a lookout for that. All right, so as far as the tax judgments are concerned that we are going to be talking about today, Constitutional Court judgments, two of them. You'll see the appellant is SARS, the other one, SARS is the respondent. And two, yeah, I'm going to say this about every case, so maybe I must just try not to say this all the time, is that these cases are really interesting and they raise some very interesting matters. Of course, by definition, they're all interesting. That's why I've selected them for the webinar. And these both dealing very much with Tax Administration Act matters. Then we'll go on and have a look at these 4 cases from the SCA. It's a selection of SCA cases. These are not all of the cases that were decided during the year, but these give us some useful guidance on various aspects. VAT, yeah, there's a few VAT things in here. There's an issue around going back to the Tax Administration Act, but also linking to the Income Tax Act and the Companies Act around a company and business rescue, HENC. When does a tax liability actually come into existence? Then we go on to the High Court, and again, 2 very much Tax Administration Act matters there. And you'll see that these cases are fairly evenly spread, as I say, Constitutional Court between appellant, respondent, SARS versus taxpayer. In the SCA, taxpayer in 2 of the 4 cases are the applicants, and the other 2, SARS is the applicant or the appellant. And then in the High Court, well, we've both got the taxpayer here. Once we've finished discussing all of the tax judgments, which will take most of the webinar, there's a little bit on sort of general tax administration. And of course, the big issue at the moment is the filing season. We still have the filing season ongoing through to January next year. And I just want to highlight some information that SARS has put out around the filing season, just in case you hadn't yet picked up on that. Right, so let's have a look at these tax judgments. Now, the Constitutional Court judgments, I mean, it's quite interesting over the years how many tax disputes are being referred to the Constitutional Court. It used to be that the SCA was the last word in the matter, and we used to think, well, you know, only constitutional matters go to the Constitutional Court. Well, that is correct up to a point, but when you have a matter of law that is of general public importance, that's generally a ground on which the Constitutional Court will allow an appeal. And so we've seen quite a number of tax appeals through to the Constitutional Court over the last few years. I've actually lost count. There's probably about 6, maybe 7 that have gone through to the Constitutional Court so far. And when we look at these 2 cases, the first one involving Medtronic, this one is actually a judgment that was handed down in December 24. But since you're probably all on holiday when it was handed down, I thought I'm going to bring it in also because it raises important aspects around the voluntary disclosure process. Now, of course, the voluntary disclosure process is this sort of a supposed lifeline that is given to taxpayers who have, you know, got into default with SARS, and this enables them to come clean on their tax affairs without criminal prosecution and without having to incur a lot of the nasty penalties and so on. But there are conditions, as we always see in the tax law. You know, it's not like anybody can just apply for the voluntary disclosure program. There are certain conditions, and there's a scope, and you have to fit within the scope of what these provisions actually allow for. Now, one of the key things in order to apply for the voluntary disclosure program is that there must be a default. And a default means the submission of inaccurate or incomplete information to SARS, or the failure to submit information or the adoption of a tax position where such submission, non-submission, or adoption resulted in an understatement. All right, so understatement, then you're linking back to the provisions around the understatement penalty. And when you look at an understatement as defined, also, this is all in Chapter 16 of the Tax Administration Act. An understatement means that there is prejudice to SARS as a result of failure to submit a return, an omission, incorrect statement, etc. All right, so there's got to be a default and there's got to be prejudice to SARS, but it also has to be voluntary. We've seen cases in the past where it has been held that this was not a voluntary disclosure, that SARS sort of coerced somebody into making the disclosure. But the key thing is that when you are looking at whether there's a default or an understatement, those matters are defined in the Tax Administration Act. Now, in Medtronic's case, and this was a case involving a massive fraud that had been perpetrated by their, let's call her an accountant, where bookkeeper, accountant, whatever the case might be, but she had been working for Medtronic for many years, and unbeknown to Medtronic, South African sort of subsidiary of an international pharmaceutical company, she had been perpetrating ongoing fraud, massive fraud, to the tune at the end of the day of about R500 million. And many times people would say, well, how on earth did she get away with that? All right, well, that's a question, I'm sure, for somebody to write a book one day. But that fraud involved that. Not entirely, but a lot of it involved VAT. And so it involved her submitting VAT returns to SARS that were understating the company's actual VAT liability. All right. And that was sort of plowing a lot of money into this fraud scheme that she was perpetrating. Now, when the fraud eventually came to light, and it wasn't SARS that discovered the fraud, it was actually an internal discovery. But when the fraud came to light, obviously, the discovery then was that, oh dear, we've got all of these VAT returns that have been under declared to SARS. So there has been a default. It has resulted in an understatement. And correctly, Medtronic then went and applied for the voluntary disclosure program. All right, so there wasn't an issue around going into the voluntary disclosure program. That was all well and good. But if you think about what the voluntary disclosure program actually allows, or what sort of relief one gets through the voluntary disclosure program, again, that is set out in the chapter 16 of the Tax Administration Act, section 229. And it tells us there that if you sign a voluntary disclosure agreement with SARS, in other words, your application for the voluntary disclosure program has been successful, then SARS basically must not pursue criminal prosecution. And that's a word in that, must not pursue criminal prosecution. So you're off the hook as far as that's concerned. SARS must grant relief in respect of the understatement penalty, and that's based on the table in section 221, or section 223 rather, where tables on the table, you've got the column 5 and 6 at the end of the table, where it tells you that although there's an understatement and it's going to result in an understatement penalty, depending on when you applied for the voluntary disclosure program, and was it before SARS started auditing that person, etc., you could, and depending on the behavior that gave rise to the understatement, that penalty could be reduced anywhere down to naught. All right, so you get a significant reduction on the understatement penalty. That's part of the voluntary disclosure relief. And then the third aspect of the relief is 100% relief in respect of administrative non-compliance penalties, all right, or a penalty imposed under a tax act, but excluding a penalty imposed for the late submission of a tax return. So in this case, if there was an understatement of VAT, obviously the correct amount of VAT would have to be determined. There was an underpayment of VAT, there was a 10% penalty that would have applied to that. That 10% late payment penalty would be waived under the voluntary disclosure relief. All right, but and when they talk about it, other than late submission of a tax return, well, the penalties, those are the fixed amount penalties for late submission of a tax return. That applies to your income tax return anyway, so it wouldn't come into the equation here. But as I've read through those three aspects of relief, you will see it says nothing about interest. Okay. Now, obviously, if there's been an underpayment of VAT over a long period of time, and you now redetermine what the correct amount of VAT is, there's going to be a significant amount of interest chargeable under the VAT Act. And indeed, that was the case. Now, the taxpayer going through the voluntary disclosure process and going through that whole process with SARS, they had applied to SARS for a remission of interest in terms of Section 39(7) of the VAT Act. And that's where basically it says in Section 39(7) of the VAT Act, it's an internal sort of remission rule for interest. And there it basically says that if this interest has arisen because of circumstances beyond the control of the taxpayer, SARS can consider remitting the interest, all right? That it says here, where the commissioner is satisfied that the failure on the part of the person which has given rise to the interest becoming payable was due to circumstances beyond the control of the person, the commissioner may remit in whole or in part the interest payable in terms of the section. All right. Now, in this particular case, you could really argue that the VAT that ended up being underpaid as a result of the employee fraud was a matter that was beyond the control of the taxpayer. I don't know why my volume would be low. I don't know if maybe I see Eric is saying that my presenter's volume is low. I wonder if you're able to turn it up somehow, because as far as I know, the mic should be working just fine. But if anyone else is having a problem with the volume, maybe you could just let me know, and I can have a look and see if there's a problem on my side. Okay, so anyway, to get back to the issue around the interest. So the interest becoming payable as a result of fraud perpetrated by the employee being a matter beyond the control of the taxpayer, one would think there would be grounds there to get the interest waived. Nonetheless, during the process of the discussion with SARS, SARS was saying, look, we'll talk about the interest later. Let's just sort out the voluntary disclosure agreement. And so once they had sorted out the voluntary disclosure agreement, thank you, Anthony, for confirming that you can hear me. So I think, Eric, maybe just check on your side. I don't know, but yeah, it seems that the volume is coming through okay for others. So in the course of the discussion with SARS said to the taxpayer, look, we'll have a look at the interest later, but let's just sort out the voluntary disclosure agreement. However, as you can see, from what I read to you earlier in terms of the Tax Administration Act, the voluntary disclosure relief that is listed makes no mention of interest, okay? So once they had signed the voluntary disclosure agreement, they then went back to SARS and said, well, can we now have a look at this remission of interest? And then the answer was, well, no, because we've now signed a voluntary disclosure agreement. So there's nothing that can be done because that voluntary disclosure agreement is the final word on the matter. And that's what gave rise to this dispute that ended up all the way through in the Constitutional Court. Now, without going into all the ins and outs, I think we do all understand that the signing of a voluntary disclosure agreement, what is stated in the agreement, overrides anything that might have been in the dispute resolution process. What you agree in that agreement is basically the final word on the matter. But the interesting question that the taxpayer was looking at here is, but hold on a minute, SARS hasn't considered our request for remission of interest. So can we insist that SARS must consider that request for remission, even though we have now signed this voluntary disclosure agreement? Now, at the SCA, their conclusion was, yes, SARS must consider that request for remission. And that's why SARS then brought this appeal through to the Constitutional Court. And they were basically saying, no, we don't have to consider the request for remission because there's nothing to be gained from that process because we've already signed the voluntary disclosure agreement. So as this went through to the Constitutional Court, and there was quite a lot of dispute around this, around what the actual outcome would be, not specifically around should we grant the remission of interest, but the question around should SARS still have a look at that request for remission once a voluntary disclosure agreement has been concluded. Now, just picking up in the judgment here, because obviously we have a limited amount of time to talk about each of these judgments, I'm going to jump through them fairly quickly. But here it was said that it would lead to a glaring absurdity to permit a taxpayer to conclude a voluntary disclosure agreement, which makes provision for interest. Well, actually, what it said is that, the interest is payable effectively because it didn't allow relief for the interest payable. and at the same time to allow the taxpayer subsequently to deal with the issues. It would destabilize the VDP framework. The finality of VDAs would be up in the air. And so they drew from the words from Endomeni. Endomeni is the kind of go-to case when it comes to interpretation of tax law. And it talks about you must look at the context and the purpose of this particular legislation. And here they were saying an interpretation will not be given that leads to impractical, unbusinesslike, or oppressive consequences, or that will stultify the broader operation of the legislation under consideration. And so they said Medtronic's interpretation, which is that SARS should still be required to consider that application for remission, they said no, that is at variance with this principle and must fail. All right, so the outcome there was that SARS won the appeal, and that was the end of the matter. I mean, it does leave one sort of feeling, well, yeah, you didn't really get a really great decision, perhaps. But the bottom line of it is, in terms of the Constitutional Court judgment, once you've signed that voluntary disclosure agreement, that overrides anything else that might have happened along the way. That is the kind of the final statement. And so whatever you've agreed in terms of that agreement, that is payable. And because the voluntary disclosure relief does not extend to interest, there's no relief that will be granted for interest. So whatever interest may have become payable along the way will in fact be payable. And even if you had applied for a remission of interest during the course of your discussions with SARS, that's going to be overridden as well by the voluntary disclosure agreement. So I think it's just really important for people to understand that absolute finality of the voluntary disclosure agreement, that you can't go back once you've signed that agreement. Okay. And the only way that one could ever go back is if SARS, if it later came to light that the taxpayer had not made full disclosure, then of course that agreement would effectively fall away. So George asked, what if the disclosure agreement, there was a statement that SARS would consider remission of interest? Well, we'd be speculating here. I would imagine that, yeah, so if it didn't sort of indicate or sort of have the assumption that the interest was payable, they said, well, the interest is contingent upon SARS having a look at that remission. SARS will go back and look at the remission. If that is specifically stated in the agreement, I would imagine, that would carry some weight, but we could only be speculating. And I think the key thing is that if you're applying for a remission of interest, get that attended to by SARS before you sign the voluntary disclosure agreement. All right, so I think that might be a clearer way to go, because if in doubt, you could end up on the back foot as Medtronic did over here. All right, so let's go on then and have a look at the next Constitutional Court case. And this one, well, it's another step in a long saga involving this Section 105 of the Tax Administration Act. And we still, in many of our tax administration cases, see reference to 105. You're going to see it coming up again and again as we go through these cases today. But in essence, these cases had happened along the way. They'd all gone, pretty much all of them had gone as far as the Supreme Court of Appeal. And you'll see that it's actually United Manganese of Kalahari versus SARS and 4 other cases. All right, so it's actually 5 cases, and I've listed them all here. It's United Manganese, Rappa, Forge, Absa Bank, Louisville Metals. In each of these cases, it was the taxpayer taking the matter on appeal to the Constitutional Court. All right, so the applicants in all of the cases were the taxpayers, you can see here, because they had all basically fallen foul of the interpretation of the Supreme Court of Appeal, and they felt aggrieved. Now, the facts were not very, very similar in all of these different cases, but the one aspect that was common was this attempt to use Section 105. And we'll come to Section 105 in a moment, but just to put it out there, that Section 105 sits in Chapter 9 of the Tax Administration Act. Chapter 9 is the chapter that deals with the dispute resolution process. All right, and the rules that are promulgated under Section 103. Section 103 sits in Chapter 9 as well. So all of that whole dispute resolution process is in Chapter 9 of the Tax Administration Act. Section 105 falls into Chapter 9. And what it actually says is that although the normal dispute resolution process is the process that one would normally follow, Section 105 kind of gives a default route. And this is what the courts often refer to it as. It's the default route to resolving something when there is a dispute. Now, in all of these cases, you'll see here, it says here the taxpayer sought review or declaratory relief or both. And I'll explain that in a minute on the next slide. But the question in each case is whether the taxpayer was entitled to pursue the relief in the High Court, having regard to Section 105. So in all of these cases, the taxpayer would have gone to the High Court and applied for relief, either review or declaratory relief. And it backfired on them. They were not successful. They then appealed to the Supreme Court of Appeal to say, hold on, the High Court should consider our application. The Supreme Court said no, and now they've appealed through to the Constitutional Court. So that's effectively what is happening here. Now, when we talk about taxpayers seeking a review or declaratory relief, so let's have a look at Section 105, all right? So Section 105 in the Tax Administration Act says this. It says, a taxpayer may only dispute an assessment or decision as described in Section 104 of the Tax Administration Act in proceedings under this chapter unless a high court otherwise directs. So in other words, it's saying you would normally and you would only be able to resolve a dispute through the normal dispute resolution process, which means objection, appeal, maybe you go ADR, but then you end up in the tax court, the High Court, etc. So that would be the normal dispute resolution process. And they're saying the taxpayer may only use that process unless a High Court otherwise directs. And so what this is saying is that in certain circumstances, a High Court may direct that a High Court would review something, all right? And there's two ways that a taxpayer could basically go to the High Court when there's a dispute around an assessment. And that is to review the assessment, and they're asking the High Court to have a look at this assessment and possibly set it aside, or a declaratory application on the correctness of an assessment or the correctness of SAR's interpretation. So a declaratory order might be, we see things this way, SAR sees things that way. It's a point of law. We have a dispute around a point of law. Let's ask the High Court to tell us what they think. And that would be the High Court declarator that they are seeking. If you think about, I think the ABSA case, many of you will remember that. The ABSA case, they were dealing with potential application of the GAR provision, the general anti-avoidance provision that sits in Section 80A through to L of the Income Tax Act. And there had been an investment that ABSA Bank had entered into, and SARS alleged that ABSA was a party to an impermissible tax avoidance arrangement. And on that basis, SARS said they're going to apply the GAR provision. Now, if they apply the GAR provision, they could basically assess ABSA as if they had not entered into this arrangement, which is seen as an impermissible tax avoidance arrangement. So basically, they could disregard that transaction and assess as they see fit. Now, what has to happen actually is that if SARS does an audit and they find that a taxpayer has entered into an impermissible tax avoidance arrangement, or they feel that the taxpayer has, they have to first issue a notice to the taxpayer telling them that they are of this view and that they are going to raise an additional assessment on the taxpayer. And in that, they're going to apply the GAR provision. And that's the 80J notice. Now, in terms of Section 80J, it tells us that SARS can issue this notice to the taxpayer, and the taxpayer is given 60 days to basically rebut SAR's argument. So the taxpayer can counter-argue and say, no, it's not an impermissible tax avoidance arrangement because of X, Y, and Z. Now, in this particular case, in the ABSA case, SARS had issued that notice, But then they just went ahead and raised the additional assessment anyway, without paying heed to what ABSA's counter argument was. And so there, ABSA went to the High Court and said, can you review and set aside this assessment because it's unlawful? It's not based on the proper legal process. And it was also looking at the interpretation of law around this whole question of whether they were a party to an impermissible avoidance arrangement. So that just gives you a bit of an illustration of when this process might be used. Anyway, as we can see from this Constitutional Court case, ABSA was unsuccessful in their application to the High Court. And the reason why they were unsuccessful is because, in essence, the court came to the conclusion that they hadn't met the necessary criteria for the High Court to give the direction in order to do the review. So we could say, did the High Court have the authority to actually review, or must the taxpayer rather go through the normal dispute resolution process? Now, all of these 5 cases that went through to the Constitutional Court, they were all heard in August 24, so just over a year ago now. But if you just think about the date of the judgment here, it took like 7 months for the judgment to be handed down. So you can see there was a lot of deliberation that was going on behind the scenes in terms of coming to a final conclusion on these various cases. I mean, each case stood on its own, but there was an overriding theme that came through, and that's really the theme that I'm going to be looking at. So basically the argument, although they sort of brought the cases together and they said, we're going to look at this particular question. Was the taxpayer in each case entitled to pursue the relief in the High Court? And if they were, what order should be made for the further adjudication of the relief? In particular, whether the matter should be adjudicated on its merits by this court. Now, must the Constitutional Court make the decision, or do they remit the matter back for hearing by the High Court or perhaps the SCA? So the key thing is, did the taxpayer have an entitlement to pursue, were they entitled to go to the High Court in the first place? Did the High Court have jurisdiction to consider each of these cases? And so that brings us to the question of, well, what would be the test? When would a High Court have jurisdiction? So if you just use the ABSA case as a sort of a case study here, if ABSA goes to the High Court and they say, we are coming here for a Section 105 review, we want you to review this assessment, and we want to review SAR's interpretation of the law as far as this impermissible avoidance arrangement is concerned, must the High Court then just proceed and have a look at that? Well, the thing is, the answer is no. You can't just walk before the High Court and bring your request for a review. The wording of the legislation here clearly says, let me just go back one slide, that the High Court must direct, first of all. So you've got to, first of all, get a direction. You've got to get approval, basically, to bring this Section 105 review. But then, how are you going to motivate for that approval? What test can you use? Now, I've given you the wording of Section 105 there, and you can see that there's nothing there that says anything about exceptional circumstances, all right? Yet, these words, exceptional circumstances, so in other words, this idea that you can only make use of Section 105 when there are exceptional circumstances justifying its use or its grant. You might say, well, where did this come from? And as pointed out in the judgment, it tells us, and if you've read through any of these judgments underlying this eventual appeal, in the ABSA case, the High Court judgment back in 2021, Sutherland basically made the point, and he said that when he was thinking about, whether Section 105 should apply, and he said, well, a court has a discretion to deviate from this default route, the default dispute resolution route. And when would the court deviate from that? It's when appropriate circumstances exist. And he said those appropriate circumstances could be labeled exceptional circumstances. And he was drawing there from that term that is used in the Promotion of Administrative Justice Act. And in the Promotion for Administrative Justice Act, it talks about the fact that you must utilize all internal mechanisms to resolve a dispute unless there are exceptional circumstances that would justify kind of leapfrogging the normal process. And so he was saying, well, we could, that idea of exceptional circumstances is really what would justify the High Court intervening in this dispute and allowing the taxpayer to jump out of the default route into a kind of a fast track route when there were exceptional circumstances. But he was really saying when there's something that would amount to exceptional circumstances. He wasn't adding words to the legislation there, but he was saying that the court would require a justification to depart from the usual procedure, and that by definition would be exceptional. But he went on to say this. He said the quality of exceptionality need not be exotic or rare or bizarre. Rather, it needs simply be properly construed circumstances which sensibly justify an alternative route. When a dispute is entirely about a dispute around a point of law, that attribute would justify exceptionality. And that's what Sutherland was saying in the Absa judgment, is that if it's a pure matter of law, that would be enough to go to the High Court and ask for their intervention. SARS is insisting on one interpretation, the taxpayers insisting on another interpretation. Let's go to the High Court instead of going this whole long convoluted route called the default dispute resolution route. Bearing in mind, if you have a look at a lot of the cases you've seen and even the disputes you're involved with, you can often see tax cases taking maybe, 5 to 10 years before they eventually make their way through maybe to the High Court, etc., to get a decision on the matter. So it can take an awfully long time. And the taxpayer was saying, well, let's cut to the chase and let's go to the High Court and ask them to intervene. And he was saying, if it's a pure matter of law, that would be exceptional enough, bearing in mind that the words exceptional circumstances don't actually exist in Section 105. And this has been a big point of contention with these 5 cases that were the subject of this Constitutional Court judgment, is most of them were basically saying, the SCA was saying there's not sufficient exceptional circumstances. So you can see in paragraph 67 of the judgment, it says that exceptional circumstances test was adopted by the SCA in Rapper, United Manganese, ABSA, and Louisville. All right, in 4 out of the 5 cases, the SCA had taken hold of this exceptional circumstances test and said there's not sufficient exceptional circumstances. Forge was a slightly different process because their leave to appeal to the SCA was refused. Now, the exceptional circumstances test is used in PAJA, as I've mentioned, in terms of exempting a review applicant from exhausting internal remedies. But in the Constitutional Court judgment, it says that an exceptional circumstances test is clear from the language, context, history, and purpose. In fact, he said, I disagree that it's clear, all right? You can't read those words into the legislation. It doesn't appear in the section. It would have to be implied. Words cannot be read into a statute by implication unless the implication is a necessary one in the sense that without it, effect cannot be given to the statute. So you have to take the legislation as it is. You can't read words in when interpreting. But what you do need to look at is what is the context? Where do you see this legislation? What is the context? What is the purpose of this particular legislation? And that's what you'd be using in terms of interpreting that legislation, but not reading words into it. Unless, as they say, you can't give effect to the legislation without adding some extra words. All right. But he was saying here, Section 105 is quite workable on its own. You don't have to read in these words exceptional circumstances. And that was a key outcome of this Constitutional Court judgment, is that exceptional circumstances is not a test per se for utilizing the Section 105 route. All right. So they say it's unnecessary to gloss the language, but nonetheless, judges would remain true to the purpose of Section 105 by asking themselves whether recourse to the High Court, rather than, you could say, the normal dispute resolution process, is appropriate, or whether there's good cause to approach the High Court rather than the tax court. And there they're saying, well, what is the test? So you're saying that there must be justification for going straight to the High Court and bypassing the normal default route. But what would the test be for granting that Section 105 direction, bearing in mind that you have to get the approval, the direction of the High Court first, before you can then put your case before them and say, please, can you review this assessment or provide a declaratory order? Sorry, I got a bit of a frog in my throat here. I think because I'm trying to talk louder, so I think because of the volume situation. All right, so the justification, they said, could fairly be tested by asking whether the departure is appropriate or is there good cause for the departure. It doesn't, they say Section 105 does not specify the factors to which the High Court would have regard when deciding whether to give a direction under the section. The High Court has wide discretion. It's neither possible nor desirable to lay down hard and fast rules on how judges should exercise that discretion. Each case will depend on its facts. Well, where does that leave us? When do you think you might have a chance of being successful? Bearing in mind that it is going to cost quite a significant amount of money to take a matter to the High Court, to ask the High Court to review something. So it might be seen as expedient, but it's certainly not a cheap or a no-cost route. You are going to have to pay for the legal counsel, etc., in order to get to the High Court. So the court did, in the Constitutional Court judgment, they did say, okay, well, what would be the factors that a court might look at in deciding whether to allow this appeal to come through to them? In other words, granting this direction. Remember that you have to use the default route unless a High Court otherwise directs. All right. So what would be the factors that would enable a High Court to say, yes, we will consider this application for a review or a declarator? It will generally be inappropriate to grant a direction if the taxpayer has not first objected to the assessment and SARS has not given a decision. So if we're talking about an assessment that is the subject of a dispute here, surely there must be an objection that has been disallowed. We must have got to that point. And if you think even back to the ABSA case, SARS had raised the additional assessment. All right, so there was an assessment there, and the taxpayer had lodged an objection. A factor mitigating against a 105 direction is when the taxpayer is pursuing other grounds through an appeal to the tax court, as piecemeal adjudication is generally undesirable. So that's the other point, is that they do not like to have piecemeal adjudication. So you can't have different matters being, some of it heard by the tax court, some being taken to the High Court. The closer a review ground is to a permissible ground of appeal in the tax court, the less likely it is that granting a Section 105 direction will be appropriate. But when a taxpayer raises a pure point of law, the direction may be appropriate. So again, if your dispute revolves around a pure point of law, that would be appropriate for possibly going the Section 105 route. The High Court must consider whether there are advantages favoring High Court over tax court, such as establishing judicial precedential value, so judicial precedent, or guiding future assessment. So if you go to the tax court and there's a decision that comes out of the tax court, that doesn't create judicial precedent. Whereas if you go to the High Court, let's say an interpretation around what is an impermissible tax avoidance scheme, or whether this person is a party to an impermissible tax avoidance scheme, what the High Court decides will create a judicial precedent. So that might be of value in that particular thing. And just giving something away, as we talk about this, with the ABSA Bank being successful in the Constitutional Court here, there is now going to be another decision that has to be made. So that question that ABSA Bank was raising, they will now go back to the High Court and say, right, now, can we have a look at this? A High Court will make a decision around that aspect of a party to an impermissible avoidance arrangement, and what they decide will create a judicial precedent. Whereas if it went to the tax court, of course, that does not create judicial precedent. And then the last point here, a Section 105 direction may be suitable in cases involving egregious and willful procedural irregularities. Okay, so especially if SARS has raised an assessment or an additional assessment without a solid basis in the law, or the administrative process has not been in line with the legal provisions. All right, then it might be appropriate to go to the High Court and say, please review this assessment on the grounds of illegality, all right, and improper legal process in raising this assessment. So those are some of the factors that would enable an appeal to go to the High Court under Section 105, as opposed to following the general dispute resolution process. And that's, again, I make the point, and sorry, before we finish that off, that this was looking at where there has been an assessment, right? There are other cases where taxpayers have applied to the High Court, and they've looked for a declaratory order around the interpretation of a provision. And that was done actually before an assessment had been raised, but it was anticipating that SARS was going to assess a taxpayer in a certain way. So that can happen as well. But these factors that they're looking at here is when there has been an assessment that has been raised, there's a dispute around an assessment that has already been raised. Then when would you be able to make use of Section 105 to review that assessment or a declaratory order around the interpretation that SARS has adopted in raising that assessment? So I think it's very useful, and there's a lot that one could say. If you look at the judgment of the Constitutional Court, it runs to over 100 pages because it's basically 5 judgments in one. So obviously we're not going to go through it in more detail than this because there's just not enough time. But I think the key aspect was that there don't have to be exceptional circumstances to make use of Section 105, but the court must be able to justify that it's more appropriate to make use of this High Court process than making use of the default route, which would be the objection appeal, tax court, High Court, SCA, etc. And these are the factors that might guide the court in coming to that decision to grant the direction for Section 105 to apply. All right, so I hope that has given you some guidance on that. I think it's Section 105 certainly has its place, and we see that it is relied upon quite a lot. But generally speaking, of course, in many, many cases, probably in the majority of cases, you are going to still be using the normal default route, which is going the normal dispute resolution process, objection, appeal, etc., etc. Okay. So let's go move on then to the next case. If there's any other questions, obviously you're quite welcome to pop them into the chat box. Did I hear somebody asking? No. Okay. Let's go on to a VAT case now, something a bit different. Let's move away from the Tax Administration Act for a moment and have a look at VAT. I think VAT is certainly a very complex area of law, and I think it's a huge area of risk in terms of businesses because of that being complex, and because many times people take principles at kind of a superficial level as far as VAT is concerned. But one has to be very precise, and oftentimes one has to have a really deep understanding of the VAT Act in order to properly apply the legislation. And most of all, of course, in business, to make sure that what you are declaring to SARS is 100% correct, that you're not making any under-declaration of a VAT liability, because obviously any under-declaration is going to result in understatement penalties, never mind late payment penalties, and never mind the whole cost that is embedded in having a dispute with SARS. Now, when we talk about an understatement of VAT to SARS, that understatement could arise from an under-declaration of output tax, or it could arise from over-claiming input tax, or claiming input tax that the vendor is not actually entitled to. And this particular case dealt exactly with the vendor having claimed input tax, which SARS considered they were not eligible for. Now, one could go back to all the basic principles, what is input tax, when can you claim input tax, etc. Well, of course, input tax is when you have paid VAT as a vendor on the acquisition of goods or services. I'm ignoring adjustments and notional input tax and all those fancy things. But in essence, when you pay VAT on the acquisition of goods and services, if those goods and services are going to be used in making taxable supplies, and if the input tax is not specifically prohibited, then you'd be able to claim the input tax as a deduction against your output tax. But of course, this issue around input tax being specifically prohibited, well, that comes in terms of Section 17(2) of the VAT Act. And it tells us that a vendor is not entitled to deduct input tax in certain specific situations, all right? And the first one, 17(2)(a), which is what we're looking at here, is when the input tax has been incurred on the acquisition of goods or services that are required for the purposes of entertainment. Now, we can say that, and we all say, yeah, we know this, we know that you can't claim input tax on entertainment, but do we really understand how broad that prohibition can actually be? Because if you start with the definition of entertainment, what is entertainment? That definition of entertainment is in Section 1 of the VAT Act. And if you look at that definition, it's one of those kind of circular definitions where it says entertainment means the provision of any food, beverage, accommodation, entertainment, there's the circular aspect, amusement, recreation, or hospitality of any kind by a vendor, whether directly or indirectly, to anyone in connection with an enterprise carried on by him. Now, yes, granted, there are some carve-outs from that, but the starting point is that we have this prohibition. Let's just go back to what Section 17(2) said. It said that the vendor may not claim any input tax in respect of goods or services acquired to the extent that they are acquired for the purposes of entertainment. All right, and I've given you the definition of entertainment. Then we do have the carve-outs, all right? And the carve-outs are that if you are running a business of entertainment, like if you're a Spur restaurant, obviously you've got to buy food and you've got to buy catering equipment and so on in order to run your business of providing entertainment, where you're actually you're making taxable supplies of food. You're selling hamburgers, you're selling Cokes and drinks and that sort of thing. And so you are running a business of entertainment. Now, in that case, that's one of the carve-outs where, yes, okay, you would be able to claim the input tax on the entertainment that you are buying in terms of the food, etc. The other aspect where you are allowed to claim the input tax on entertainment comes into this little section that's referred to over here, Section 17(2)(a)(1)(b)(b), all right? And that says where the vendor supplies entertainment to any employee or office holder of the vendor or any connected person in relation to the vendor, to the extent that the taxable supplies of entertainment are made for a charge which covers all direct and indirect costs of entertainment. All right, so if you're supplying entertainment to an employee, office holder, or connected person, to the extent that the taxable supplies of entertainment are made for a charge which covers all direct and indirect costs of the entertainment. All right, now, in this particular case, the taxpayer was conducting the enterprise of shaft sinking and mining. Okay, so clearly not actually in the entertainment business, okay? But in the course of carrying on the enterprise, not entertainment, enterprise of shaft sinking and mining, they had put up certain employees at hotels and they had paid for food. So they were providing accommodation and food for these employees. And we saw from the definition of entertainment that it specifically covers food and accommodation, all right? But there is this carve-out that says that if that was provided and you were charging a cost that covered all direct and indirect costs of that entertainment, then you would be able to claim the input tax. So Avenge was claiming the input tax on the basis of saying, well, we're entitled to claim the input tax, all right? But SARS said, no, you don't fall within this carve-out provision and you are not entitled to claim the input tax. So the question was whether that input tax was deductible whether accommodation and food were required for making taxable supplies of entertainment in the ordinary course of the enterprise. Well, they're not in the entertainment business, all right? But that's subsection AA that we would say doesn't apply. But then subsection BB coming back here, was it supplied to employees for a charge? And if so, was that charge sufficient to cover all direct and indirect costs of the entertainment? Now, this has gone all the way up to the SCA, all right? And Avenge has taken this matter up to the SCA after losing its previous appeals with SARS. So SARS had one argument, and the taxpayer was saying they were entitled to the input tax. And they said it should be deductible. Basically, number one, the expenses were factored into the contract price that the vendor was charging its clients. And therefore, it was recovered. So the food and accommodation costs of putting up employees in accommodation out on site near the mines, etc., they were charging their clients enough to cover those costs, and therefore they should be allowed to claim the input tax. Because that carve out in subsection BB, they said, allowed for input tax to be deducted when those expenses were charged back to employees or, as I mentioned there, not just employees, but also any connected person in relation to the vendor, if all direct and indirect costs were covered, and that VAT operates under a neutrality principle to say, look, you're charging VAT. The essence of VAT is that you should be charging VAT on a value added. And if this is a cost of the business in order to add value, and the output tax is going to apply on the added value, this cost is one of our costs that we incur in order to add that value. And if we claim the input here, it's only because somebody else has raised the output. And so there's this neutrality. Someone else had the output, we've got the input, and so SARS is not losing anything. But SARS's argument, on the other hand, was that the expenses for food and accommodation fell squarely within the definition of entertainment as defined, and these deductions were prohibited unless a specific exception applied. Remember, I'd mentioned those two exceptions. The vendor, they said, was not engaged in the business of entertainment, so that exception was not going to help them. The second exception in that subsection BB, they said did not apply because this was food and beverages provided to employees of the vendor, and the vendor was not charging the employees for the costs. And it did not conclusively prove that all of the direct and indirect expenses were recovered from the clients. And they basically said the neutrality principle, really, you can't use that as an argument because we've got specific statutory prohibitions. And the VAT Act's prohibition on input tax on entertainment was a legislative safeguard against potential tax abuse. Now, let me just come to this point around the prohibition on the deduction of input taxes, all right? We're talking here about input tax paid on goods or services acquired in the course of obtaining entertainment of some type. There's also input tax paid on the acquisition of a motor car. It doesn't matter whether that motor car is used for making taxable supplies or not. If it falls within the definition of a motor car, you can't claim the input tax on the acquisition of that motor car. And then, of course, there's also the prohibition on subscriptions to recreational clubs and so on. Now, we might say, well, why are those particular prohibitions in the VAT Act? And it actually goes all the way back to the original design of the VAT Act. And bearing in mind, the VAT Act has been with us since 1991. So we've had this now for, 34 years, all right, going on 35 years. And if you are as old as I am and you remember when VAT came in and took over from GST, you will remember that the VAT Act, our whole VAT system was based very closely on the New Zealand system. And we adopted a lot of the principles that apply in the New Zealand system. Now, in that New Zealand system, they have this idea that one has to protect the fiscus from abuse. And so that's why you put some of these sort of protective mechanisms into the legislation. And certainly in our VAT legislation, these provisions to prohibit the deduction of input tax in these, let's just say these three main areas, entertainment, motor car, and club subscriptions, where you're talking about social and recreational clubs, all right? they were just regarded as areas where there could potentially be abuse. And so it was decided we're just going to provide this kind of blanket prohibition on claiming input tax in these particular areas. All right, and so that's what they were saying is a legislative safeguard against potential tax abuse. So you can't argue and say, well, it is used for business and therefore we should be allowed the input tax. The point is that there is just this statutory prohibition. And it doesn't have to follow logic. It is just a statutory prohibition that was put in there as a safeguard when the VAT legislation was actually promulgated. Now, the judgment at the end of the day. So what was the outcome of this? I think if you are thinking along the lines that I was thinking of, you're thinking, well, did the vendor actually charge enough to the clients to cover the direct and indirect costs of that entertainment? And if they did, then surely they would be allowed to claim the input tax credit. Well, the judgment looked at the preamble to look at the exceptions, all right, to the carve-outs from the general prohibition, subsection A and B, as I highlighted to you. And basically, they said goods and services acquired for making taxable supplies in the ordinary course of an enterprise making supplies of entertainment. And they said, well, this vendor's not making supplies of entertainment. That's not their enterprise. And so the input tax is not going to be allowed on that basis. These goods were acquired for making taxable supplies in sinking mining shafts, not for providing entertainment. So at that preliminary level, the appeal would fail. But what about the next aspect, all right? The next aspect is that subparagraph BB, supplying entertainment to any employee or office holder of the vendor or any connected person to the extent that the vendor has made taxable supplies to a client at a charge that covers both the direct and indirect costs. Well, here, interestingly, the judgment came to the conclusion that Avenge had failed to prove, they had failed to discharge the onus of proof upon them to show that they have fully recovered the cost of those entertainment expenses. And so because they failed to prove that they had done a full recovery, on that basis, the court said that the appeal must fail. They said in the alternative, if it would be sufficient to recover the charge from the clients, they said they haven't recovered it from the employees directly. If they had recovered it from the clients, they would have to prove that they had charged enough to cover all the direct and indirect costs. And they said Avenge hadn't satisfied the onus there. And for that reason, the appeal must fail. So a bit of a sad outcome for Avenge there. I kind of think, I wonder, if it was a fair judgment. It seems from what I've heard that Avenge had put a huge amount of information forward to be considered in this case, and yet they still lost the appeal. But be that as it may, I think the principle that comes through to us is to be extremely careful when you are claiming your input tax deductions in the course of doing VAT calculations. And of course, also making sure that you have systems in place that are sufficiently rigorous that, input tax would not be allowed to go through the system and be claimed unless you're 100% sure that you are eligible for the deduction of that input tax. Because not only did they suffer the pain of not getting the input tax deduction, but of course they also then had the late payment penalties and the interest that would have been payable on this under-declaration of VAT. So quite an expensive and sad day in court for that particular vendor. Right, then we cross over and look at something completely different. In the case of Henk, it's actually a closed corporation, but of course that falls into the definition of a company. So we talk about a company here. And it's a company that is in business rescue. Now, interestingly, this company that was in business rescue, we'll go through the whole background here, but it had submitted a tax return before the business rescue process started. And then after the business rescue process had commenced, SARS raised an additional assessment on the taxpayer. And that additional tax liability that came about from the additional assessment, the question then, was that a post-commencement debt or a pre-commencement debt? In other words, did that debt arise before the business rescue process or after? And that's a critically important point, because that that business rescue process, the commencement of business rescue, actually sets a line in the sand. If you think about it, you've got all of your liabilities that arose before the commencement of the business rescue, and they basically are the subject of the whole business rescue process to work out how those liabilities are going to be settled, etc. But then you've also got post-commencement liabilities, and they have a completely different kind of legal status, as it were. Interestingly, with this particular taxpayer, they had this additional tax liability that came about from this additional assessment that was raised after the commencement of the business rescue process. And there was also, in that post-commencement process, there was a VAT refund that came to light. All right. There was a VAT refund that was due from SARS. That was not a point in dispute. But what SARS wanted to do is they wanted to offset that VAT refund against this additional income tax liability that arose from the additional assessment. And the taxpayer said you can't set them off because the income tax liability actually is a pre-commencement debt, whereas the VAT refund is post-commencement. So they fall on different sides of that line of when did the business rescue actually commence, and you can't muddy the waters, you can't mix the two. And so it raises this critical point. The VAT issue was not what was in question, but the income tax liability that arose from the additional assessment. The question is, when does that tax debt actually come into existence? Does it come into existence when that additional assessment is raised, or does it come into existence at an earlier time? And it's obviously a really important point. Now, we've had this question before, but in a different context. And that was in the Visa case, where SARS was looking at basically taking out to basically secure the taxpayer's assets. And they were accusing the taxpayer of dissipating assets of a certain company ahead of an assessment being raised. And the taxpayer was saying, well, there was no tax debt at the time that this dividend was paid out. And then the question in that case was, when does a tax debt come into existence? But that was in a different context, dealing with the collection of tax debt and the preservation order that SARS was seeking to secure. So now in this particular context, when would a tax debt come into existence? When an assessment is raised, has that tax debt only come into existence when the assessment is raised, or at some previous point? And based on that, would SARS be able to set off the VAT refund against this income tax liability, or must SARS pay out the refund and leave the income tax debt to be dealt with separately? Right, so let's just have a look at this. Now, the background is that Henk had filed the 2017 tax return reflecting a tax loss, and that was assessed almost immediately, as SARS tends to do, and that was assessed in November 2017. All right, they did, though, inform Henk that they were going to carry out an audit. Henk then commenced business rescue process on the 31st of January. First meeting of creditors and employees was held on the 12th of February. So here, the business rescue process commences, all right? At that point, what we have as far as SARS is concerned is zero liability, because we've got this tax return that shows a loss of 46,000. But then, after the business rescue process has started, SARS completes the audit in April 2018, and they identify that actually there's taxable income of 16.8 million. And that gave rise to income tax liability with penalties and interest of some 5.6 million rand for that 2017 year. But of course, this additional assessment was raised in April 2018 after the business rescue process had actually commenced. So the assessment was raised on the 4th of April. The due date for payment was the 31st of May 2018. The business rescue plan was tabled on the 31st of May, adopted by creditors on the 13th of June. And that business rescue plan included other tax liabilities, VAT and PAYE, which were pre-commencement debts, but said nothing about this additional tax that had been assessed. All right. because, as I say, they listed SARS as far as that tax assessment was concerned, showing a liability of nil based on this loss of 46,000. But now that SARS raised the additional assessment after the business rescue process had commenced, SARS said, well, we've now got an income tax liability of 5.6 million. We've got a VAT refund that has also arisen in this post-commencement period. We're going to just offset the VAT refund against this tax liability. And that's where the taxpayer said, no, you can't do that because the tax liability is a pre-commencement debt and the VAT refund is post-commencement. So in order to address this question, of course, one has to look at the Income Tax Act and especially Section 5(1), which establishes the general liability to pay income tax. You've got to look at the Tax Administration Act and the specific provisions dealing with assessments and what is an assessment, and that would indicate to us when the tax debt is raised. And then, of course, the Companies Act dealing with business rescue proceedings, especially Chapter 6, and that looks at the treatment of pre and post commencement debts. Now, if we look at the Companies Act and we look at the provision, and let's just look at this one provision around business rescue. This provision in Section 128(1)(b), in the process of a business rescue, which is, of course, and I'm sure you all know, it's a legal process designed to facilitate the rehabilitation of a financially distressed entity, and it involves a business rescue practitioner, and it involves placing a temporary moratorium on the rights of claimants for those liabilities. And that's where you've got a certain legal status for your pre-commencement debts, all right? Those liabilities are the subject of the business rescue process. And that's that temporary moratorium on the rights of claimants on those pre-commencement liabilities. And in fact, in Section 154(2), it says that no creditor, including SARS, can enforce a debt which was due and payable prior to the commencement of business rescue, so a pre-commencement debt, except in terms of the business rescue plan. All right, so the business rescue plan might come to the conclusion that there's certain compromises that are going to be entered into, and that whatever those liabilities were, maybe we're going to only settle 50 cents in the rand, or whatever the case might be. So that's what's agreed in terms of the business rescue plan. And apart from that, no creditor can enforce the repayment of any other debt. All right, so those pre-commencement debts have a certain legal status, and then your post-commencement debts have a different legal status. So those pre-commencement debts are ring-fenced because they arose prior to the commencement of the business rescue. I'm not going to worry about that last point. Now, when we came to this question of when did that tax debt actually arise, this tax debt that came through from the additional assessment, which was raised, remember, in April 18 with a due date for payment end of May 18. That was after the commencement of the business rescue process. Now, the High Court, in looking at this question of when did the tax debt come into existence, this was the judgment from March 23, they looked at a Namibian Supreme Court of Appeal case, Esselman versus the Secretary of Finance. And in that particular case, it was stated that although income tax is payable annually on taxable income, the taxpayer is not liable for payment until an assessment is raised. And the issuing of a notice of assessment is crucial to the establishing of a tax debt. And they referred to Section 5, and they said if you look at Section 5(1)(d) of the Income Tax Act, it is quite clear that income tax only becomes due and payable when an assessment or additional assessment is basically raised on a taxpayer. Now, let's just have a look. What does Section 5(1)(d) actually say? It says basically that normal tax will be levied on the taxable income received by a recruiter in favor of any company during every financial year of a company. So it's not really specific. It just says that your income tax is based on your taxable income derived by a company during a financial year. But on that basis, they came to the conclusion that only when the assessment is raised is the tax debt basically originating. And they said, well, in Henk's case, this additional assessment was only raised after the commencement of business rescue. Therefore, that's a post-commencement debt. It's not a pre-commencement debt. Well, that's the whole point that Henk was taking on appeal through to the SCA. And when they went on the appeal to the SCA, applying for declaratory relief, have a look at this. Okay, so here's a point of law where they disagreed. Okay, so this interpretation of Section 51D, SARS said it means that you have to have an assessment, and basically that assessment was only raised after business rescue had commenced, and the taxpayer basically said, no, 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 they saw it differently. All right, so now, interesting here, the SCA said the High Court had jurisdiction and Section 105 direction was not required because it did not involve an assessment. And that was a point I was stressing earlier when I was talking about the Constitutional Court decision around Section 105. All right, so they said the High Court did have jurisdiction, and basically the taxpayer was disputing the manner in which SARS characterized the income tax liability from the 2017 additional assessment. And basically, when did that liability arise? If it arose pre-commencement, you can't have a post-commencement VAT refund being set off against that pre-commencement debt. Right, so what did the SCA say? When does a tax debt come into existence? Now, they recognize Section 105 and says, yes, that imposes a liability for income tax in respect of the taxable income derived during a year of assessment. But when exactly does it come? When does the tax debt come into existence? They said immediately after the end of the year of assessment or shorter period, the tax debt is owed, even though it may not yet have been quantified and is not yet due and payable. They say the process of quantification by means of raising the assessment, which originates from a submission of a return by the taxpayer, basically that happens in a later period after the end of the year. In terms of Section 66 of the Income Tax Act and the raising of an assessment in terms of Section 91 of the Tax Administration Act. And so that notice of assessment fixes the date by which the debt becomes due. All right, so it tells us when the debt is payable. We saw earlier the additional assessment in this case said that the assessment must be settled by the end of May 2018. But that's not the date on which the debt comes into existence. That's telling us when the debt becomes due and payable effectively. All right, so they're saying, let's just have a look at what this additional assessment is. And they said SARS is empowered to raise additional assessments, etc. And that results in a re-quantification of the debt. So in this case, the original assessment said there was no debt. They re-quantified that with the additional assessment. Now, notice this point here. They say the re-quantification of the debt in the additional assessment does not create a new liability. It's just re-quantifying. It's just changed the quantum of that liability. So a debt is not originating when the assessment is issued. The debt originated basically at the end of the year of assessment based on the transactions entered into during the year of assessment. It's not dependent on the assessment being raised. They said SARS financial year ended on Feb 2017. SARS issued the original assessment in November 17. That was after the financial year end, prior to the commencement of the business rescue. Therefore, any income tax liability in respect of that year was owed. So this is where the tax liability came into existence, was at the end of the 2017 financial year, which obviously was prior to the commencement of the business rescue process. And so the conclusion was this is a pre-commencement debt, which obviously was good for the taxpayer because that meant that you couldn't have that and the VAT refund, which was post-commencement, you couldn't offset them against each other. Interestingly, they also said any liability for VAT, not looking at this refund situation, but just generally, they say the liability for VAT is created by Section 7, which is the charging provision of the VAT Act. And that section provides that VAT shall be levied and paid on the supply by any vendor of goods or services supplied in the course of carrying on an enterprise. And so they make the point that if you had to say, when does a VAT liability come into existence, that is going to be when that supply is made. So at the time of supply of goods or services, that's going to give rise to your VAT liability. of course, reduced by any input tax that the person may claim. So, I mean, there you would probably say that in reality, it's at the end of the tax period, although here they were saying it's at the time of supply. So maybe there's a little bit of a dispute there. Is it the actual time of supply, or is it the end of the tax period where you actually take your output tax minus input tax gives you your VAT liability? But the point of the matter is that it's really the supply that gives rise to the debt, not the raising of an additional assessment by SARS, if they do raise an additional assessment. And so if we look at the set-off, could SARS set off the VAT refund against the income tax liability? Well, look, the Tax Administration Act does allow set-off under Section 190 and 191, but it disallows set-off in certain circumstances when you've done a suspension of payment, etc., or a payment arrangement. And also in terms of the Companies Act, Section 133(1)(c) prohibits legal proceedings and enforcement actions, including set-off, against a company in business rescue, unless the set-off is against a claim made by the company itself. And that's a legal safeguard, the court said, to prevent creditors, including SARS, from bypassing the protective framework of a business rescue process. So in essence, it comes back to this very clear line between pre-commencement debt, post-commencement debt, and the protection mechanism is that you can't mix the two. You can't set one off against the other. And so the conclusion was that SARS could not set off the VAT refund against the income tax liability because the VAT refund fell into the post-commencement phase, whereas the income tax liability was a debt that arose pre-commencement of the business rescue process. And so the taxpayer's appeal was upheld with costs, and that order of the High Court was set aside. So quite an interesting outcome there. And I think if any of you are involved in business rescue processes, that is no doubt a judgment that would be of interest to you. Right, I see that it is 26 minutes past 2. I wonder if let's just start on the Virgin Mobile case and see how we go. We're going to take a break. We said at 2:30. Still a Supreme Court of Appeal decision, and this is an appeal brought by SARS, right? And it's from the High Court up to the Supreme Court of Appeal, and it is dealing with an interesting aspect of the Tax Administration Act, the application for a default judgment. Now, this application for a default judgment is a very powerful remedy that is available in terms of the rules promulgated under Section 103, so what we call the dispute resolution rules. And in this particular case, the taxpayer can apply to the tax court for a default judgment. And if they are granted that default judgment, that links to Section 126 of the Tax Administration Act. In essence, if the taxpayer was successful with this application for a default judgment, it could mean that whatever assessment SARS had raised could be set aside. And so if SARS had raised an additional assessment, but this had gone on appeal, and there was a dispute between the taxpayer and SARS, if there was improper behavior on SARS' part, which is basically what was alleged in this particular case, and if the taxpayer was successful in going the default judgment route, they could actually get the tax court to overrule SARS' additional assessment, and that decision is final, and it would cause the additional assessment to fall away. So it's a very powerful remedy that is available to the taxpayer, this Rule 56. So here the taxpayer had applied for a default judgment, but the issue is whether actually that default judgment was kind of justified, because there was a story that happened along the way here, of course. This is a matter or a dispute that had gone on appeal, and the taxpayer had lodged an appeal against SARS' disallowance of their objection. And then what should happen after they have lodged an appeal is that SARS should then reply with what is called their Rule 31 statement. And that's their statement opposing the taxpayer's appeal. And that statement has to be lodged within 45 days of the appeal notice having been lodged by the taxpayer. And here SARS was way out of time. They had not lodged their Rule 31 statement. And so they were in default. They had not met the timeline that is imposed in terms of these rules. Now, what would happen there is there's a number of different things, all right? There can be an application for condonation or for an extension of that timeline, and that can be done, it can apply to either party. If either party needs more time to comply with these timelines and the rules, they could apply for an extension of the time period, and by mutual agreement, the parties could agree to that extension. But SARS had not applied for any kind of extension. In fact, they had just done nothing in spite of the taxpayer bringing to their attention that this Rule 31 statement was way outstanding. Eventually, the taxpayer did put SARS on notice by issuing them with a warning to say that if you don't, and this is the Rule 56 notice, and it basically says if a party has failed to comply with an obligation prescribed under these rules, the other party may deliver a notice to the defaulting party informing them of the intention to apply for a final order under Section 129. That's the application for a default judgment. And basically, the other party will go ahead with that application if the defaulting party fails to remedy the default within 15 days of delivery. So SARS was in default. They hadn't provided the statement. The taxpayer put them on notice, issued them with this Rule 56 notice saying, you need to fix this default within 15 days. Otherwise, we're going to go ahead with our application for a default judgment under Section 129 of the Tax Administration Act. But then what happened is that very soon after SARS, the taxpayer issued this notice to SARS, SARS then came up with the Rule 31 statement. And so it was within the 15 days prescribed by Rule 56. But the taxpayer said, no, 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 you never asked for condonation. You never applied for an extension for submission of this Rule 31 statement. You were way beyond the 45-day period. And you can't now just fix the default by coming up with this Rule 31 statement and saying, well, everything's now fine. We can just move on. And that was the issue here, is that SARS said, well, actually, we are no longer in default because we've now provided the statement. And the taxpayer was saying, you are still in default because you never applied for condonation of the late submission of this statement. And so if SARS was still in default, the taxpayer could go ahead and apply for the default judgment. If they were no longer in default, then obviously the taxpayer would have no grounds to apply for the default judgment. Now, I've given you all the timelines here, but I've kind of explained what this default was and the fact that the Rule 31 statement was outstanding, etc., and that SARS had not applied for any extension under either Rule 4 or Rule 52, which is another remedy that is available. But they did jump and provide the Rule 31 statement when the taxpayer issued them with the Rule 56 notice. Now, the tax court had dismissed SARS' application on the grounds that SARS was obliged to comply. They said SARS must follow the proper process. You can't just put the Band-Aid over all of the other requirements by coming up with your Rule 31 statement after Rule 56 has been applied by the taxpayer. And in the tax court, they said on a proper interpretation of all of these rules, SARS should still have applied for an extension or a condonation of late submission, and therefore they were still in default. But notice here, of course, it was SARS that appealed up to the SCA, going back to the outline here. It was SARS that appealed to the SCA, basically saying, no, 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 we are no longer in default because we have fixed our default by providing the Rule 31 statement. Their appeal to the High Court was dismissed, and then they went on and appealed to the SCA. So the crux of the matter is whether SARS was still in default or not, all right? SARS argued that they were no longer in default because they had provided the statement. The taxpayer said they were still in default because they had not applied for condonation of their late submission. The conclusion of the SCA, now bearing in mind this involved a very large case, and if the default application went ahead, SARS additional assessment could just simply fall away, and that would be the final outcome of the matter. So it's quite a drastic step that would be taken. So the court, possibly understandably, was quite split here. This ended up being a majority decision, not a unanimous decision. And the majority of the High Court found it irrational that a party can ignore the rules and wait for a Rule 56 notice to comply, and so avoid having to apply for condonation. The High Court ought to have held, they said, that a party who is served with a Rule 56 notice need not apply for condonation after complying with the notice. So they were saying, although they should really apply, but if they've fixed it by submitting the Rule 31 statement, then that should be sufficient. And they're basically saying that SARS was successful here and they're entitled to its costs. Well, it's a good outcome for SARS, but it leaves us in an interesting situation because it does mean that if you put SARS on notice by issuing the Rule 56.1 notice, and they then provide the outstanding Rule 31 statement, as it was in this case, then that overrides any other problems that have happened in the past around timelines, and everything is now fixed, and the matter will proceed. And it raises the question around whether, if SARS did apply for extensions along the way in terms of Rule 4, if they applied for extension of the normal timeframes, should the taxpayer grant those extensions by being nice to SARS? And in the past, many people have said, well, yes, you should just, be nice, be a nice team player, give those extensions. But I've heard it mentioned now from some senior counsel who are saying, well, hold on a minute now. If we're saying that, just by the taxpayer providing this Rule 56 notice, SARS can then remedy all of its previous defaults by just providing the outstanding information, then actually the sooner you go and make use of this Rule 56.1 notice, the better. So let's push SARS to meet those deadlines. If they fail to meet the deadlines, issue the Rule 56 notice, and that would expedite the process of SARS then providing the outstanding information. Because usually when a taxpayer puts SARS on notice with the Rule 56 warning, then SARS normally jumps very quickly and provides the outstanding information. So it's it's an interesting judgment, and I think it does maybe change the playing field slightly as far as managing the default situation with timelines is concerned. All right, but it is now time to take a bit of a break. I've gone a bit over now. We set a 15-minute break. So Danny, if you could just keep a time and maybe pop time onto the screen and say we will resume at 14:51, and I'll see you back then.
Yes, Jennifer. Yes, Jennifer, I'm in a meeting. What do you? Yes, Jennifer. I can't talk. Yes, Jennifer.
It's reprinting. I can check it, but it should sound more. Thank you. It's submitted. Have you ever done that before? The reprinting. I'm sure it was okay.
All right, thank you all. We should be coming back soon. Jackie, just note there's one question in the chat box and one in the Q&A.
Great, thank you. Yeah, thanks, Danny. Let me have a look at the one in the chat box first. That's looking at slide 18, all right, and that's quoting from this judgment in the Arendse case, basically saying where the judge said, assuming the taxable supply of entertainment is made for a charge, Arendse failed to recover the charge from its employees. In the alternative, in other words, saying if we could recover the charge from the client, if it would be sufficient for the purposes of the exception to recover the charge, it failed to establish that what it built into the price charge would cover all the direct and indirect costs. Yeah. If it would be sufficient for the purposes of the exception. And so, yeah, he's not specifically proclaiming on that because that wasn't, that would be beyond. What he's actually saying is that the taxpayer had failed to discharge the owner. So he's not proclaiming that, yes, it would be sufficient, because actually the finding of the court was that the taxpayer had failed to discharge the onus by providing enough information. Well, yeah, that point, I know practically people are saying, was that correct? But the point here is not saying that it would not be sufficient. He's saying, yeah, if it would be sufficient, they haven't discharged the onus. But the question here from Sishle is saying, so employee entertainment is claimable, etc., if the vendor can claim full recovery. Well, that is what is indicated by that provision in the legislation. But what we have here is that the court hasn't specifically pronounced on the interpretation of that provision. But if you look at section 17.2, 1ABB, etc., it says, if the vendor supplies entertainment to the extent that the taxable supplies of entertainment are made for a charge which covers all direct and indirect costs of entertainment. So you'd have to actually show that you are specifically charging your client for that, and you're charging something that is sufficient to cover all direct and indirect costs. So yeah, it's a non-decision on that score, because the decision was really that the taxpayer had not discharged the onus. So yeah, look, it leaves us with a little bit of, okay, but then what? Unfortunately, that's just what happens with many of these judgments, right? They're not necessarily giving us a tax opinion on the whole matter. They're just looking at the particular legal question. And then Anonymous says, please advise for VAT purposes, most companies render 201 on a 2-monthly basis. Okay, well, I mean, that depends on your VAT registration, all right? If you're a category A or B vendor, then you supply on a 2-monthly basis. If you're category C, then you have to supply on a 1-monthly basis. And so it just depends on your registration category. And category C, basically, if you look at the registration criteria, category C is looking typically at your large companies. I think the cutoff is 30 million. So that takes you into category C. Or if somebody has been in default, then they put on a kind of a 1-monthly, because SARS wants to keep tabs on their submissions. But generally speaking, it's for your larger companies. Okay, so it depends on your registration status. Your registration category, all right, what category are you registered under? Right, then I think that's answered all of those questions. So let's carry on. So let me get back to, I was on slide 30. I'd finished talking about the Virgin Active case, and let's now look at the Woolworths case. So now back to a VAT question. This one, a VAT question that has been asked a few times in the past, notably 2 particularly important cases dealing with holding companies. And of course, when you're dealing with holding companies and this issue around whether the company is carrying on an enterprise, making taxable supplies in the course of carrying on an enterprise. Now, Woolworths Holdings, we all know Woolworths, and Woolworths Holdings, as the name suggests, is a holding company with a number of subsidiaries. And they were entering into a certain corporate transaction, which we'll come to the details of that just now. And the question was effectively the VAT implications of that transaction. Now, you'll see here that this is a SARS appeal from the tax court up to directly from the tax court to the SCA. So the tax court had found in favor of Woolworths, obviously, and SARS was saying, no, we're not happy with that decision. And the decision revolved around input tax. Well, it actually had an aspect of input tax and output tax. But let's look at the input tax side. And it was looking at whether Woolworths Holdings was entitled to claim an input tax credit. Again, we go back to this question of whether you can claim the input tax. In this case, in respect of fees charged by a service provider, a South African service provider, who was providing advice. It was a sort of a merchant bank, as it were, providing advice on this corporate transaction. And so South African provider of the services, charging VAT on those services, Woolworths had claimed portion of the tax as an input tax deduction. The question was whether an entity conducting an enterprise as an investment company, a holding company, is entitled to deduct input tax in respect of the costs incurred. And these costs related to a rights offer made to shareholders to raise capital for further investment, which would increase the value of its investments. Well, of course, when you look at the question of when can a vendor claim an input tax deduction, and we go back to section 17, we go back to the definition of input tax, etc., and we're saying when VAT has been paid on the acquisition of goods or services to the extent to which those goods or services are used by a vendor in the course of making taxable supplies. All right, so if you have mixed supplies, both taxable and exempt supplies, obviously you can only claim input tax. The portion of the goods or services that are used for making taxable supplies, that's the portion of the VAT on the acquisition of those goods and services that you can claim as an input tax. Now, that is on the basis that the vendor is carrying on an enterprise, all right? What is an enterprise? Well, if you look at the definition of an enterprise in section 1 of the VAT Act, and I'm not going to read you the whole definition, but I'll just give you a little start to it. It talks about any enterprise or activity carried on continuously or regularly by any person in the Republic or partly in the Republic, in the course or furtherance of which goods or services are supplied to any other person for consideration, whether or not for profit. And then it goes on to include and exclude certain things. So we're talking about an enterprise or activity, let's say a business activity, carried on continuously or regularly. So there's that aspect of carrying on business, carrying on regular activities, in the course of which you are making a supply of goods or services for some form of consideration. All right. Now, in Woolworths Holdings case, if this was just a straight holding company, holding shares in subsidiaries, I think you would agree with me that there's probably no regular continuous activity going on there. And that was the view that SARS was taking with Woolworths, is that they were saying that they're not carrying on an enterprise as such in terms of these regular and continuous activities of making supplies for consideration. But there was something important that distinguished Woolworths from the other similar cases involving holding companies. And there, in the other companies, the other cases, we'll see them just now, De Beers and Consol, in both of those cases, the taxpayers were unsuccessful in claiming their input tax in a similar situation because they were regarded as just holding companies that are not actually carrying on continuous activities. In the Woolworths case, let's just have a look at the background to this and see what was actually happening. So Woolworths in 2014, they bought back all the shares in David Jones, all right? That was that Australian venture that did not go well for them, and they decided to bring it all back in-house. And they did an acquisition of all the shares in David Jones Limited for 21.4 billion. Now, that acquisition, well, that's one thing, but what we're focusing on is part of what funded that acquisition, because that 21.4 billion was funded by cash, debt, and a rights issue. It was all of this that we had the advice provided to us for which we would charge fees, on which VAT was charged, okay? Now, specifically with this rights issue, the underwriting services basically were provided by resident and non-resident providers. We'll come to the non-resident aspect in a moment. But as far as the input tax is concerned, there we're talking about resident providers of advisory services. They're charging us a fee, they're charging us VAT, and we are using that advice for this whole transaction. The question is, can they deduct the input tax on those fees? But as far as the non-resident providers are concerned, there's an equal and opposite thing that has to be considered here, because when we have non-resident providers, if you think about it, that non-resident provider is not a VAT vendor. They're not charging VAT on their fee. They're not raising VAT on their fee. So when we as a South African company pay the non-resident provider, we're paying them a fee. There's no VAT in there. But Section 71C, and I mentioned this section earlier, I said it was the charging provision of the VAT Act. And we got Section 71A talking about your normal taxable suppliers, B talking about imported goods, C talking about imported services. And C, Section 71C requires a vendor to raise an output tax liability on the acquisition of imported services. But the thing is, imported service is a defined term. So it's not just any service that is acquired from a non-resident provider. By definition, imported services means a supply of services made by a non-resident supplier. And then it goes on to say, to the extent that such services are utilized or consumed in the Republic other than for the purpose of making taxable supply. So when I say equal or opposite, you can claim your input tax on your local service provider's fee to the extent to which that fee is used for making taxable supplies, right? As far as your output tax on the imported services is concerned, you have to raise output tax on these the fees from your offshore providers of service only to the extent to which those fees are used other than for making taxable supplies. So this output tax is raised on your non-taxable element, if I can put it that way, and input tax is claimable on your taxable supply element. All right, now I make that point because when we talk about this rights issue over here, we are issuing shares to the existing shareholders, okay? And it's quite an interesting one that when you look at the shareholders of Woolworths, some of those shareholders are residents and some of those shareholders are non-residents. Let's leave the understatement penalty for now and go on to the next case. In fact, I just want to give you a little bit more info before we do that. So in terms of the shareholding, we've got resident shareholders holding a certain portion of shares, non-resident shareholders holding a certain portion of shares. If we do a rights issue from Woolworths to the shareholders, there's a certain supply that's going to resident shareholders. And that supply, that share issue, is actually an exempt supply. It comes into the definition of financial service as defined in Section 2, and that becomes an exempt supply in terms of Section 11. On the other hand, the issue of shares to your non-resident shareholders is actually a zero-rated supply. Okay, so that's actually a taxable supply. So if you looked at this whole transaction here, buying back the shares by issuing, doing a rights issue, the issue of the shares through the rights issue contains basically an exempt portion, being the portion of shares going to your resident shareholders, and a taxable portion, being a zero-rated supply, on the shares going to the non-resident shareholders. And of course, that feeds through to this whole question of input tax, output tax, okay? What is the taxable supply aspect here with input tax? It's going to be the portion of the fee that relates to the shares issued to the non-resident shareholders. That's your taxable supply. And to what extent do we have to raise output tax under Section 71C? Well, that's in terms of our foreign service providers, their fees, to the extent to which they are used for non-taxable purposes, which is your exempt supply. That's going to raise output tax. So, and this was an opinion that Woolworths had obtained, and they had declared there that according to that opinion. You'll see the detail of that coming through as I talk about this a little bit more. And of course, SARS disallowed that. They said that actually there's no taxable exempt because we've got a holding company. They're not really carrying on an enterprise, so they're not making any supplies. And so basically they can't claim any input tax, and they should raise all of the output tax on the imported services. Now, the tax court upheld the taxpayer's appeal against SARS disallowance and the insistence that they must raise the full output tax on the imported services. And the tax court remitted the understatement penalty. And that's why SARS took this matter on appeal, as you can see from the name of the case. All right, so appealing against the tax court decision. The tax court said the input tax was deductible, that portion of the input tax, because Woolworths was an active, not just a holding company, but an active investment holding company engaged in acquiring and managing investments, raising capital and providing support to its subsidiaries. So not just an investment company, but an active holding company. And the court upheld Woolworths' argument that the rights offer and the related services were integral to its enterprise, that it was carrying on an enterprise. Remember, I gave you the definition of enterprise, where there must be continuous activities going on, making suppliers for consideration. And they were saying they are doing that. And the rights offer is integral to that enterprise. And the expenses were for the purposes of making taxable supplies. And the services supplied to resident shareholders were exempt, being financial services, as I mentioned just now. And the services, the issue of shares to the non-resident shareholders, were zero rated. So if we had to split those between taxable and non-taxable, okay, taxable was the portion of the fees that related to the rights issue going to the non-resident shareholders, that's a zero rated supply. And the non-taxable element was, of course, the exempt portion, the portion of the services that related to the rights issue going to the resident shareholders, because that was an exempt supply. Well, SARS didn't agree with that. Now, let's just have a look at that. So the split of shareholders between resident and non-resident, 54.44% of the shares were held by resident, 45.56% by non-resident. Okay, so if they incurred VAT in respect of the South African underwriting fees, so we've incurred VAT, South African provider, what input tax can we claim? Well, based on the Woolworths approach and based on the opinion that they had obtained, they would say to the extent to which those services are used to make taxable supplies. All right, so only the portion that relates to the share issue going to the non-residents. And on that basis, they deducted input tax of 8.5 million, 45.5% of the VAT. So they claimed input tax 45.56 of the total input tax. When it came to output tax, they said, right, what is the fee paid to our non-resident service providers? We've got to raise VAT on the portion of the fees that relate to non-taxable services, which would be the exempt portion, that's the 54.4%. We don't have a specific number attached to that, but that would be the principle there. Now, this was in line with the tax opinion that they had obtained, that the supply of shares to residents is an exempt supply and the supply of non-residents is a zero-rated supply. So Woolworths deducted their portion of the input tax and they raised output tax relating to the non-taxable portion of those imported services. Now, SARS' argument in essence was that they were not carrying on an enterprise. There's no continuous activity. They said that prior to the acquisition of the David Jones business over in Australia, they had not engaged in the activity of issuing shares in a continuous, unchanged or uninterrupted manner. So they were looking at the issuing of shares and looking at that activity and saying, but you don't do that on a continuous basis. They didn't trade in shares, etc. But Woolworths is saying it's not just the share activity that we are involved with. We are actively involved in managing our subsidiaries. We're an active holding company, an active investment company. And we're involved in the decision-making. We're involved in appointing board members. We're involved in the management of our subsidiaries. And no doubt they charge management fees to their subsidiaries for that purpose. So Woolworths was arguing that they did carry on continuous activities, but SARS was saying, no, you are not, and therefore you're not really carrying on any enterprise whatsoever. You have no taxable supplies as such. Well, the conclusion of the SCA was in favor of Woolworths, saying that they were an active investment holding company and raising the capital was just part of that whole enterprise that they carried on. So whereas De Beers and Consul had previously been unsuccessful in similar VAT disputes, the court here said that these facts were distinguishable because of this active element, this active management, that they were actively involved in the management of the subsidiaries. They were not just holding the shares in those subsidiaries. And that's in essence where these facts were distinguishable. And so whereas De Beers and Consul basically had no taxable suppliers, so there was no input tax, and they'd have to raise all the output tax on imported services. But Woolworths, on the other hand, they were carrying on an enterprise. And if you then came back to the specific transaction of the rights offer and saying what were the services that were feeding into that rights offer, in the course of carrying on an enterprise, part of that rights offer related to exempt supplies, the shares going to the resident tax holders, and part of it related to zero-rated taxable supplies, and those would be the portion of the services that related to the non-resident shareholders. So that was confirmed by the court. And so Woolworths was successful in that case, and the understatement penalty fell away. So a very interesting outcome there. And I think a very important outcome for holding companies. And I think it's a glimmer of light in this kind of sea of darkness where we've had holding companies having, very little maneuverability as far as VAT is concerned. So the issue here is that this was distinguishable on the basis of this being an active investment holding company. All right. Just going back to the questions and actually linking back to the Henk case, that was the case of the company that was in business rescue. Basil asks, have SARS appealed the Henk case to the Constitutional Court? Well, I don't know. I do wonder if they have. I'm not sure. Because he says he has an identical situation with SARS setting off post-commencement refunds against pre-commencement. Well, you see, the thing is, in terms of the Companies Act, and I cited the relevant provisions in the Companies Act, that you have got this ring fencing. And this case, because it tells us that the tax debt came into existence prior to the business rescue, that's why, on that basis, you would not be able to do the set-off. But of course, yes, if they take this matter on appeal, then it is going to have a different outcome. But I'm not aware at this stage. I don't know. I don't know if it's gone on appeal to the Constitutional Court. So at this stage, it's a little bit of a gray area, except for the decision we have from the Supreme Court of Appeal in the Henk judgment. But you say here that SARS do keep telling you that they're considering the appeal to the Constitutional Court. Well, we don't know yet whether it is going to be allowed to be taken on appeal to the Constitutional Court. It remains to be seen. So at this stage, it's a big unknown, I'm afraid. Okay. All right. And there's nothing in the Q&A, so let me carry on. So the last two cases that we're talking about are now coming down to the High Court, and I'm just going to mention these cases very briefly. JMAT involved ETI credits, and quite an interesting one here is that they did the whole EMP5. Basil, yes. And that time has expired now. So, but there's nothing that has been disclosed, and I'm not aware. I'm not involved in the internal mechanisms of that case, so I really can't say what the outcome of that possible appeal to the Constitutional Court is. All right, on the JMAT case, they had been claiming ETI credits. They submitted the EMP 501. And then they wanted to change the EMP 501 and go and claim more credits. But SARS ignored their later submission of the EMP 501. And they then applied through the Promotion of Administrative Justice Act, saying this was unfair administrative process. But they didn't stay within the 180-day period, which is imposed under Section 71B. Because basically they were saying, what was the date? When do you start counting that 180-day period? What was the date on which the reasons for the administrative action became known or ought reasonably to have become known? Okay, from that date, you count 180 days, and that's the deadline by which you have to bring your application if you are going to apply this provision. Now, in this particular case, SARS had notified the taxpayer that they were not going to be revising their EMP 501. In fact, if you have a look on the SARS website and the guidelines around the EMP 501 and the ETI credits, etc., the ETI Act does actually make it clear that you close off your ETIs at the end of a particular 6-month period. Once you've submitted that reconciliation, that is pretty much final. So SARS had advised the taxpayer, but then the taxpayer went back and asked again, and SARS issued another letter. And the taxpayer was counting their 180 days from the second letter. But notice here it says the first date on which the reasons should have been known. All right. And unless the second letter changed what was made known when the first letter was issued, one has to come back to the date of the first letter. We've seen this in previous cases as well. And so the finding here is that the applicant was made aware of SARS reasons in the sort of earlier letter, and therefore they had gone beyond the 180-day period and the application was dismissed. So just be careful of that. You know, if you are going to make use of an application around Promotion of Administrative Justice Act, please be very careful of that 180-day deadline, because we have had other cases where taxpayers had been unsuccessful as well. And this one was Suku and another versus SARS and another. This involved a preservation order. There was certain companies, well, I'll get into the detail of it in a moment. But the question here was, can the scope of a preservation order extend beyond the original purpose for which it was granted? In this particular case, quite a convoluted set of facts, as we often see with these cases. We had a company, Kagiso Africa, which obtained a tender to supply PPE to SARS during COVID-19 pandemic, and to SAPS rather, sorry, not SARS, SAPS, and they received 134 million rand in 2020. That 134 million rand came into Kagiso for the purchase of the PPE. It was immediately transferred, and Kagiso didn't declare any of this to SARS. SARS raised an estimated probable tax liability, including penalties and interest, for 86 million rand. There were no assets in that Kagiso Africa. They sought a preservation order to prevent any assets of the applicants or any other person against whom the probable tax liability may be collected. So that's your sort of related parties, so that the collection of tax would not be frustrated. So they applied for this preservation order. And SARS stated that the basis of the application was that after Kagiso had transferred the funds, the remaining balances in the account were insufficient to meet the probable tax liability. All right, because bearing in mind that they had not declared any of this income to SARS. So there would be a tax liability that would arise, but now they had no assets, and SARS would not be able to collect the tax liability. So anticipating that there would be a future tax liability, they sought a provisional preservation order in 2021, and that was confirmed in January 23. And then in June 23, SARS raised the assessments for the second applicant, and that would be for the owner and his company. And that totaled 8 million rand, including penalties and interest. Now, the applicants contended that the assessed liabilities fell outside the scope because the original preservation order was taken against Kagiso itself, whereas SARS then raised assessments against these other parties that were related to Kagiso through the sort of shareholder, director of Kagiso and his other companies. But the second applicant, which was another company of that shareholder, didn't actually owe SARS any debt in respect of this PPE transaction. But SARS argued that the preservation order that they have obtained was still necessary to collect all of the tax that was outstanding. And they had commenced audit investigations into the tax affairs of the first applicant, the shareholder, and there were reasonable grounds to believe that he too would owe income tax once the audit was completed. So they wanted to keep that preservation order alive. But in terms of Section 163 of the Tax Administration Act, that tells us that a senior SARS official basically tells us the circumstances where they can obtain a preservation order. It's an order for the preservation of assets of a taxpayer or any other person, prohibiting any person subject to the conditions and exceptions as may be specified from dealing in any manner with the assets to which the order relates. Now, the court in this case took the view that there are two grounds on which an application for the preservation order may be sought: when the full amount of tax is due and payable, or when an official on reasonable grounds is satisfied that the full amount may become due and payable. And SARS relied on this ground, anticipating that there would be a tax liability that would become due and payable. And that's when they applied for the preservation order. But then there were other tax liabilities that arose in different parties, albeit connected persons, but not the same taxpayer. They said the PPE contract was awarded to Kagiso, and that constituted the reasonable ground on which the application was launched. But when it became clear after the SARS investigation, the second applicant did not, in fact, have a liability relating to that PPE transaction, the ground for the preservation order ceased to exist. And it says there that the preservation order is no longer in force and effect if the assets subject to the preservation order are no longer required for the satisfaction of that or the tax debt. So that preservation order was no longer in force, they said, in relation to the assets of the applicants, the related parties. So yeah, it's just maybe makes the point that when you have a preservation order, there's a certain scope. So that preservation order covers certain assets related to a specific taxpayer, and you can't then extend that to other assets of other taxpayers, even if they are related parties. But if their tax liabilities arose from a different transaction, it can't come under the same preservation order. So that's a point that is being illustrated there. Okay, so that's all the tax judgments that we need to discuss today. And then just to finish off, because we did also say talking about tax administration and sort of general tax matters. So just wanted to bring to your attention updated SARS interpretation notes. Remember, the interpretation notes are stating SARS interpretation. And so these are not binding. It's not legislation as such, but it is indicative of how SARS will interpret certain provisions. And so it is important to be aware of what these interpretation notes contain. So I've just given you there a list of the interpretation notes that have been updated. There's quite a number of them. All right. Most recently, IN 10 dealing with skills development levy exemption for PBOs, and IN 44 dealing with capital gains tax implication of PBOs. There have also been two new interpretations, in fact, sorry, four, just two in the last month, but four new interpretation notes that have been issued. Here we see number 136, 7, 8, and 9. You'll see that there is a bit of a focus on PBOs as well. And so IN 136 talks about non-professional sport and recreation, looking at the 9th schedule. IN 137 looking at when you have a change of use of assets, when an asset commences to be held as trading stock. So let's say you have an asset that was a fixed asset and now it becomes part of the trading stock of the taxpayer. As a fixed asset, you'd claim certain allowances perhaps, and now that you have a change of use, you've got to look at the market value of the asset on the date of change of use, and that can give rise to certain recoupments. And so that's what that interpretation note is referring to. And then coal, which I think we don't need to look at the Mineral and Petroleum Resources Act. And the last one is a taxation of amounts received by or accrued to missionaries, and that's looking very specifically at the gross income definition, especially paragraph C, any amount received by a person, received or accrued as a result of services rendered to any person. So it doesn't have to be under an employment contract, but there is an amount received in respect of services rendered. So there is that causal connection. Look, gross income definition does extend very broadly. And so I think if you are dealing with anybody who might be a missionary in terms of any religious organization, it would be worthwhile having a look at interpretation note number 139. Okay, and then the final one is on the filing season. And I'm sure you're all aware of the notice. In fact, I would have talked about this in our previous update back in May. The notice that was issued to SARS to indicate who has to submit a tax return, notice number 6217. And then there was another notice issued on the 4th of July, extension of a date to request a reduced or additional assessment. Now, this links to, sorry, just jumped ahead there. This links to where there has been an auto assessment, because in terms of section 95(6) of the Tax Administration Act, and basically, although auto assessments are not issued because the taxpayer has failed to comply with any kind of obligation upon them, auto assessments are issued really to expedite the assessment process. But nonetheless, they come into section 95 as being a form of an estimated assessment. And when you have an estimated assessment that has been raised by SARS, especially where it's been raised because the taxpayer does not submit a return, not because they've failed to submit a return necessarily, but an auto assessment, there's been no actual return by a taxpayer, SARS has raised the estimated assessment. It says that in essence, the taxpayer would have 40 days in which to submit any outstanding or any tax return that would override or cause an additional or reduced assessment to be issued instead of that auto assessment. So in other words, if you were auto assessed and you did not agree with the auto assessment, you would need to submit a tax return in order to get SARS to rectify that auto assessment. If you worked according to the ordinary rules of the Tax Administration Act, Section 95(6), you would have 40 business days from the date of the auto assessment to make the submission of that tax return. Bearing in mind that your auto assessments were raised typically early in July, you count 40 days, that would take you through until kind of late August in order to submit your tax return, which seems a bit unfair, right? Because other taxpayers, if they're non-provisional taxpayers, they have until, or they had until the 20th of October to submit those tax returns. So this notice extends the date instead of that 40-day period, because it does say 40 days or a longer period as the Commissioner may prescribe by public notice. And this is where the Commissioner is making use of that option, and they're prescribing by public notice. Then when you are dealing with an auto assessment, in order for the person to get SARS to correct that auto assessment, you have to submit a tax return. That it's not going to be the 40 days necessarily, it's going to be that normal tax submission deadline date, which was the 20th of October. All right, so that's in essence what is contained in this notice. And I've given you a live link on the slides there so that you can actually have a look and see what is in the notice. But it simply says that if the person has been auto-assessed, they can request that additional reduced assessment by submitting the outstanding or the tax return by the 20th of October 2025. All right. But if the auto assessment is raised after the 22nd of August, well, then what would happen is that that 40-day period would go beyond the 20th of October. And so you no longer need to rely on the 20th of October in that case. Then you back to basically the 40-day period that would normally apply. Okay, so that's essentially what is happening over there. Now I need to try and get back to my Zoom camera, which I've now lost. Okay, let me just get my slides back on the screen. Hopefully you can see them. Let me just get them. Yeah, there we go. Okay, right. And then, yeah, so that additional notice. So basically what we're saying is any person who is auto-assessed, provisional or non-provisional, if they were auto-assessed, before the 22nd of August, they would have up until the end of, or the 20th of October to submit the tax return in order to get an accurate assessment. If they were assessed after the 22nd of August, then they've got that 40 business day period in which to submit the tax return in order to get an additional reduced assessment. Okay. And then the other announcement that came through around trust income tax, SARS has been putting out quite a bit of information around trusts. It is worthwhile to go and have a look at the website, basically saying the key date for trust matters. So remember, all trusts, whether provisional or non-provisional, the deadline for submission of the 2025 return is the 19th of January 2026. But as far as your 2025 year of assessment is concerned, remember that we now have the obligation on trusts to submit the IT3T return, and that is a return setting out distributions to shareholders. And that the deadline for submission for the 2025 year of assessment is the 30th of September. Now, interestingly, the filing season for trusts opened, I think it's 20th of September, and then it runs through until the 19th of January 2026. Trustees still have until the 30th of September to submit their IT3T returns. That's a third-party returns, as I say, setting out the distributions to the beneficiaries. It's compulsory to submit those returns if there have been distributions to beneficiaries. And those, yeah, so that'll have to go in by the 30th of September. That information might not necessarily be pre-populated on beneficiary tax returns at this stage, but SARS will use it for validation purposes. Going forward, the intention certainly is to pre-populate that information on the beneficiaries' tax returns. But bear in mind, and this is a point that comes through on this overview of important updates on the SARS filing season. So if you click on that link and it takes you through to the SARS website, and it also tells you about legislative changes. And remember that the one important legislative change is that Section 25B was amended to make sure that the flow-through principle only applies to resident beneficiaries. And that was amended with effect from the 1st of March 2024. So it had effect for the first year for the 2025 year of assessment. All right. So that is going to affect also the tax returns and the provisional tax returns for that particular year, for the 2025 year. All right. So if you have a distribution to a non-resident beneficiary, that distribution would not flow through and get taxed in the non-resident beneficiary. It's going to be taxed in the hands of the trust, or perhaps in the hands of the donor, if Section 7 applies. Okay, so just watch out for that. Click on this link to get further information from the SARS website around trusts. Trusts, one has to be very careful with your declarations, and obviously make sure that you get your IT3T returns in, and make sure that all the beneficiaries and the trusts are picking up the correct amounts that come into their respective taxable incomes. All right, so good luck with that. Good luck with the filing season. I think that does bring me to the end of what I wanted to discuss today. So it leaves a few minutes for questions. If anybody does have any questions still, you're very welcome to raise them. Danny, I don't know if I don't see any in the Q&A, but if there are any questions, please feel free to raise them. Otherwise, I'll hand back to you, Stan. And just while I do that, let me just say thank you very much for having me this afternoon. Thank you for the opportunity of presenting the webinar to you, and wishing you all the well until I chat to you again at the end of November. All the best to you all. Thank you. Yeah. And handing back to you, Stan.
Thanks again, Jackie. Just checking, you did cover that comment by Basil.
Yeah.
You did. I mean, just keep a check. Again, it's just seeing a lot of thank yous. See, nothing's come up yet. If anyone else wants to actually say talk through a question, I can make them give them permission to talk if that is needed. Just let me know. Put a hand up in the chat, and I can do that for you.
Okay, you've taken away my video so nobody can see me, but I think they can hear me. Just on a couple of points. Firstly, we're coming to, and I'm just going to start my video. We're coming to the end of the year, and there are two more webinars coming, one at the end of October, one at the end of November, and the one is on AI in October, and at the end of the year, Prof. Jackie will be doing the year-end update. That's at the end of November. Thank you for attending this afternoon. A very interesting, well-compiled talk. And thank you, everybody, for joining us.
Before we go, can I just mention, sorry, Jackie, did you see there's a question from George, tax returns for freelancers? Where can we get some literature as guidance?
Oh, okay. Okay, so, well, freelancers are essentially independent contractors, I would imagine. Of course, you got to ascertain that. As an independent contractor, it's an individual carrying on business, usually as a sole trader. So that is, you're going to operate on the basis of a sole trader. And so you would declare their income through the normal individual's tax return, the ITR 12. All right. So SARS did put up a notice recently about social media influencers, interestingly enough. And I guess, it's a similar principle to what they've had a look at under social media influencers. Interestingly, they said that SARS has a special unit that is looking at social media influencers to make sure that they are declaring all of their income properly, including any benefits that they might be getting through their influencing operations. And I would imagine, you could draw a lot of commonalities between the two, although I get it that freelancers are a little bit different, but there are a lot of areas of commonality. So literature as guidance, you're looking really as your independent contractors, your sole traders, your individuals carrying on business as essentially consultants or, something of that nature. So I guess that's where you would be having a look at. You can have a look at SARS tax guide. It's very generic, but otherwise pick up one of the sort of typical tax textbooks and just, you're just working through the normal thing of what comes into gross income, What are your deductions that you're entitled to? Maybe home office expenses you need to be looking at. It's those areas. And as I say, they usually operate in their own name. But of course, if they're operating through a company, then you've got to have a look at that whole issue around, the company situation, and be very careful about whether they are regarded as personal service providers. But otherwise, yeah, you just go according to the normal tax rules. I hope that helps you.
Okay, so to wrap up, to all our Jewish colleagues, coming up New Year and Rosh Hashanah and Yom Kippur, and wish you well for the New Year and a meaningful fast. To everybody else, thank you again, Jackie, for well presented and well compiled talk. And to everyone else, thank you for joining us, and thank you for the afternoon, and good night.
Good night. Thanks very much. Goodbye.
Thank you all. Cheers.